Hey, what's up, guys? Ivan here. Welcome to Music Color, the place where we're helping you to boost your producing and marketing skills while watching, learning, winning. On this channel, we're sharing with you our producing experience, also showing you cool tips, tricks, marketing strategies, free courses, and many more. So if you're new here, consider subscribing because we have new video every week and new giveaway every 2 weeks. That's right. Every 2 weeks, you have great chance to win great plugins and studio equipment.
Ownership. It's so important for you to understand that ownership is fundamental building block for your success as a musician. And I will explain why in a few minutes. But first, let's make sure we are on the same page in terms of understanding what property there is to own. In the music industry, we commonly deal with sound recordings, copyrights, and song copyrights. And each of those is independently piece of property. They can be independently owned and they can independently exploited. So let's learn what sound recording copyrights and song copyrights are. The song copyrights originates from a writer song. If I sit down on my PC and complete a song, or if I take a pen and write down a song, the moment I complete that song, I've completed a song copyright. It's a word of music or lyrics in music, depending how you hear it. But the basis of this piece of property that it's a song and it's a result of copyright. In the other side of that, if we have song with perform and recorded whatever, if it's a CD or MP3 file, the result recording is a sound recording copyright. And that's a separate piece of property. When we took at ownership, we have to look at both pieces of property. So let's look at few examples, and I will start with song copyright and figure out few scenarios will help you understand how ownership can develop and work. In first scenario, I may be a songwriter and I may sit down, write chords or lyrics of a song that I want, and when I finish that, when it's complete, I can step back and release that since I'm the only person involved determining ownership. It's fairly straightforward. It's me and I am the solo owner. But let's look at two different examples. When I'm songwriter in a context of a band, I sit down, I write a song, and I think it's complete. And then I took it to the band and I say, hey guys, let's work this song through. And as we do, the song involves, and maybe there is a few lines that added, or maybe a melody change, some differences in a song development, and by the time we complete there is slightly different song. Maybe it's very similar to that one I've made that originally I wrote, but slightly different. Here is the question. You have asked yourself, was the song copyright complete before bringing to band, or did it become complete after the band participate? And that's an important question before you finish the determination ownership, because it will be very easy for you as a songwriter to assume that you own the song outright. So looking further to that explanation, what we have is the majority of work was done, the original writing and creation of that song then was taken to the band, and you have this other participant that contribute to the development of the song. Arguably, the band members are in a title of something, but what? And that's a question bands often face. Whatever they are songwriters, musicians, or both. So I participate in a process and I'm expecting something, some portion of ownership or authorship, but I'm not sure what exactly it is, right? The decision to determine ownership flows pretty much from logic and common sense. What do you think each person is entitled to? And it's not solo in the person who started writing a song. It's only entire band for that determination we made. And the worst scenario, the band never discussed song ownership and it's left to chorus to decide and just to sit there and look at circumstances and determine what ownership percentage is appropriate. So we hold off on that scenario and I will take another scenario where I am a person that physically writes down a song or takes my laptop to practice and come out with something. But writing a song in a context of the whole band performing together. So what we have here, it's a contribution that looks more equal. It's term who involved in the process and the development of that song. And even though maybe the one who's actually transcribing that song to paper. I'm not the actual person that's responsible for writing it, and I'm in a creativity sense. It's all the band members. So here, if you are looking for ownership and wanted to make it fair, determination of who owns what, I think there is a fair argument each member of the band is gonna have interest should look more like to all other members of the band. And you can't look at yourself as being a transcriber of offering something more in terms of creativity that should entitle to greater percentage. But again, there is things that work out in the concept of your relationship with other band members. And if you are a solo artist or a solo songwriter, usually don't deal with that. But when you're in a band, you have to face those issues. So, when is the right time to face them? The right time to face those issues is before the song is written. That's right. Before you start to writing down a song, chorus, melody, everything, first thing you should do is put down the paper, make a contract, and just make sure that everyone is happy of the percentage that he will receive after the song is finished. And the best way to deal with them is by writing agreement, as I said. So what I will suggest you in terms of dealing with those ownership issues is the context of the band. When you're dealing with the song copyrights, sit down with the band, talk about who's contributing, talk about what the expectations are, and make sure that everyone voices an opinion, and then put it down on paper. Here is what we agree for all of our songs, or just for the some particular songs, but whatever it is, put it on a paper. Work it through before the song are written. And trust me, you will have much more success as a songwriter, musician, and a band. Sound recording ownership. Okay, now let's assume that we determined all ownership issues. We've looked at all the people involved to writing a song, that song copyright is fully developed, and now we're going to record it. What we're gonna look at here is, again, who's involved in this creative process in creating a sound recording. If we simply go into one of our band members' garage, for example, and set up all our equipment and hit the record button and start playing and develop that copyright. And once again, the sound recording is finished, like a digital file, doesn't matter if it's MP3 or WAV file or physical format like CD. When it's complete and band members were the only people involved in developing that sound recording ownership, it's again very easy to determine. But now let's look at percentage. Now I'm in the band context where nobody else were involved. My argument would be that everyone was contributing pretty much on equal basis, and that should entitle everyone to a similar percentage of ownership in that sounds recording. But let's say that your band hired a studio and maybe hire producer, sound designer, mixing, mastering engineer, or other individuals to get that CD recording. When you step back and look at all individuals involved in the process to create that CD, it's very important to point out is that you not only have the band members, but also have producer, studio, and sound engineer, and maybe some other people. My point here is to identify each and every person that's involved in that creative process. And again, you step back before the CD is recorded. You identify each one of them, sit down and talk about the issues of ownership. What are their expectations? Because some studios you may pay and they will have contract ready for you to sign, and in the contract they will say exactly what's gonna happen in terms of their claim of ownership in your resulting CD. Maybe they will claim an interest or they will totally disclaim it. But if you don't address those issues, if you don't read the contract, you will never know. But when you do hire out the studio or you rent any space with those other people involved, it's important to identify all people involved that you have discussed with each and every one of them and discuss those ownership percentages, and again always put it on a paper. So now there you have determined song ownership for the underline song copyright, and if it addressed all of the issues of ownership for the sound recording copyright, you have complete ownership package, and it should be written in form of a contract in minimum. You should write down in a piece of paper, write out all the terms you have agreed to. Write down the percentages or dollar amounts, whatever involved, but it should be reduced to writing. The correct way to view ownership. I'm gonna answer the question why understanding ownership is so important. First, we're moving forward. In order to protect your copyrights, you have to register them in Copyright Office. In order to do that, you need to know who owns the material that you're about to protect. If you don't know the answer of that question, you can't properly protect your material. So, understanding ownership and determining it before you protect the work is a fundamental building block. The other part of this is your ultimate goal as a musician or as a songwriter is to get some kind of contract or publishing deal or recording deal. If is that what you're looking for, you have to understand that record labels or the publisher, they're gonna ask you that question, who owns this material? And if you don't know or you tell them something wrong, you're gonna be in hot water. The contract they will have you sing it, you will specifically say that you own and represent this material, or that you have the rights that you're giving to the publisher or the record label. And if that turns out not to be true and there is success with the song or sound recording, and there will be knock on your door or the record label's door. With the producers were involved to the creativity process that wanting them royalty check. It's gonna be a big problem for you as a musician, and it's gonna cause you instant problems with your record label or publisher. That's why handle those issues early on the game, figure them out, resolve them on a paper, and you will be ready to move forward to the next step.
What happens to ownership when bands break up? Because we know they often do. Well, the answer is the ownership still remains relevant long after the band fall apart. So, when you have a situation when one or two members of your band are on the new endeavors, they're operating as a solo artist or in the context of the band, and they're using the same materials. And let's simplify this. They're using one song that the original band wrote together. And now two different people are exploiting that song in two different circumstances. How do you deal in that situation? Well, first you need to be preempt to your approach to deal with the ownership. If you set each other down early on before the song was written and work out the agreement, you already know the answer of the question. And if you did it, will be very easy to deal with when the situation came up. As the weather can't stop one person or another from exploiting that song, and band agreements often do have provisions dealing with music after the band breaks up. And it's very important that you do deal with the situation, but if you haven't, how do you address the situation? The ownership interest has not changed. The exploitation of the song is what changed. So, the deal with the situation, let's say one of the members of the band have to contact to other members of the band that is using also the song and come to the table to deal the situation, to deal with the specifics of what rights can be exploited and by who. And let's also take this step further. If one of the band members, or the same as in first case, two band members try to independently register the song copyright with the copyright office, you're really in trouble. Because now it's potential the copyright office will assume issue registration for two different artists for the same song, which is essentially setting both of you of copyright infringement action against each other. Again, simplify the process, work out ownership issues before with your band, work out agreement with your band, work out what is gonna happen if bands break up, how can the music be used, who's gonna control it, work these issues in advance because it's very complicated to fix all those issues after the band break up.
Protecting your materials. We've looked at ownership and we resolved all the issues of ownership of songs and sound recording copyrights. But now we need to move over into the subject of copyright protection and figure out how the best to protect your work. But first, let's dispel some of the rumors about the poor man's copyright. The poor man's copyright is essentially pulling your song or CD into the envelope and mailing it to yourself. Once it comes back, locking it away in a safe place in the hopes that if somebody infringes your work, you will be able to pull that envelope out and prove something. But we don't know what your hope is that it will prove that you own the materials that are inside of it, and it will also prove that that you created it by the mailing stamp. But this is not what happens in reality. A judge has even looked at this very specific case and said that since it's so easy to open an envelope that's been sealed to change or put different contents in the envelope and reseal it without notice, it's essentially worthless in the eyes of the law. But more so than that, federal copyright law, which is the operative law protection of your songs and sound recording copyrights, does not make provisions of the poor man's copyright. So don't waste your time with a method that is not secure in the eyes of the law and really does not prove any logical protection. Now, let's talk about copyright registration and what it means. But before we can get into that, we need to look at the possibility of copyright existing without registration. Copyright exists of the moment that you complete a written song or sound recording. Copyright exists to protect that material from infringement, and if you do not have registration, you are limited to a certain of specific rights. You can stop somebody from infringing your work, and you can recover actual damage if you can prove them. The difficulty with actual damages is they're not only difficult to prove, but sometimes they simply don't exist. For instance, let's say you've recorded a CD and somebody has taken that CD and duplicated 100 times and locked those copies away in their garage and haven't sold them or give them away to anybody. I will be able to sue that person to stop him from further infringing of my rights of duplication. But what about actual damages? I can't prove that they've made any money because they haven't sold out the CD. They haven't given them away to someone to some benefit to themselves. And I can't prove likewise. And I can't prove that I've lost out on a opportunity for money because the person isn't selling or giving them away to somebody that I may sell or give them away to. So, if I can't prove actual damages, I'm only left with the possibility of stopping the person from further infringements. But understand this. The prerequisite to bring a suit for infringement is registration with the Federal Copyright Office. So, even if you complete copyright a song or sound recording and you've been moving along without registration, if somebody infringes your work and you intend to stop them, you're going to have to register your work, which leads to the conclusions that you need to register your work right out of the gate. Why waste time? So you may have heard around that copyright will protect your work without registration. And yes, that's true. The law doesn't make allowance to protect your work, but you can't enforce those rights unless you're registered your work. Now, let's talk about copyright with registration. Copyright registration is essentially administrative function whereby you will complete a form. You will submit that form together with an appropriate fee and appropriate number of copies of your materials to the Federal Copyright Office. If your submissions complies with all of the rules, will return a certificate of registration. And once you have that certificate of registration, you will entitled to a number of very important rights for you as an artist, recording artist or songwriter, or both. First, you're gonna have the ability to stop somebody from infringing your work. So if we look back at the first example where somebody is duplicating your CD, even if they are putting them aside in their garage, you're still going to be able to stop that person from further infringing the duplication right. But now you also have the ability to recover actual damages. But again, we do have circumstances where actual damages are either hard to prove or they don't exist, like the first example. But if you can prove actual damages, for instance, that some person now goes out and sells your CDs, maybe at swap meet, all of the revenue that that person generates by infringing your copies, you can recover as actual damages. Or if there is a lost opportunity, if you're able to prove that because this person infringed my rights and I lost this valuable opportunity, I'm entitled to specify dollar amount. Those are actual damages, but let's operate under the assumption that you can't prove your actual damages. What's left? Well, with federal copyright registration, you also get the benefit of electing statutory damages. Now, statutory damages is a range of dollar amount, range set by statute. The judges will apply based on the specific facts and circumstances of your case. So if you look at the scenario where a person duplicates my CD and maybe they duplicated it 1,000 times, but they locked those copies away in their garage. They didn't sell them to anybody and didn't give them away. So I can't prove actual damages. What I will do instead is elect statutory damages. And in that case, the judge will attribute a dollar amount that I'm entitled to as a result of that conduct. And that dollar amount can range up to $150,000 per incident or infringement. So the statutory damages component of federal registration is an essential part of protecting your works. Now, to bring infringement action is very costly. You're going to have to hire an attorney. With registration, you also have the potential of recovering your attorney fees, all the money that you spent trying to stop somebody from infringing your work, or recover dollars amount in actual damages of statutory damages. Now, you also have the ability to recover all of your attorney fees that you're incurred in going after that person. Copyright without registration does not permit you recover attorney fees, even if you're subsequently registered. So you have this limitation without registration, but this significant benefit if you have registered your work. Finally, copyright registration will also prove you with presumption of ownership and with a public record of the time that created a work whenever you submit the form. The information that you put on the form becomes a matter of public record. And so, if there is a dispute as to when you've created that underlying song copyright or that sound recording copyright, the form that you've submitted has that information. And if there is a dispute and maybe the information's inaccurate or incomplete, the fact that will come up in the case will help you resolve that. But the presumption is your favor as the copyright owner. Now, how do you register your copyrights? First, we're going to look at the song copyright. The song copyright will submit on Form PA, and the form it's fairly straightforward. Here you will put contract information, song title information, and some of their items, and submit that with appropriate fee and appropriate number of copies. And so each time you will write song, it's important that you register that song on PA form with Copyright Office. Sound recordings, on other hand, are submitted on Form SR for sound recording. And again, you will fill the same virtually the same information, and you will submit the form along with the payment and along with the specific number of copies. Once that information is submitted, those materials are submitted. At the same point, you will receive back registration certificate, wherever it's for your song copyright or your sound recording copyright. But if you're writing a lot of music, you have maybe 100 songs or maybe 100 recordings, individual masters, singles, wherever they may be, that can get very costly. If you have to do copyrights registration form for each and every one, will be very expensive. So let's answer a few questions. Can you submit multiple songs on a single form? And the answer is yes, you can. If all of the ownership class authorships information is identical, so if myself or me together with my band have written all of the songs that wish to submit and all of the information is the same for all of those, I could submit 100 songs on a single PA form, and that will work without any issues. Likewise, on the sound recording, the hour form, if I have 100 sound recordings, maybe 100 individual masters that I hope to secure, copyright protection for and all of the ownership/authorship information is identical. I could submit all of those on a single SR form, which is great because the cost can really add up when you're submitting multiple songs or multiple sound recordings. Can you submit a song recording and a song together on a single form? The answer here again is yes, but it can be technical. The key is if you're going to submit a sound recording and a song together on a form SR, and where you're looking at what is protected. You're protecting not only the sound recording, but the underlying words and music. So what's important to remember here? When you're trying to submit songs and sound recordings on the same form, is that not only the ownership/authorship information identical, but also that you're protecting all of the underlying words and music for all of the song recording and sound recordings. Once you do that, you can get registration with a single registration form. Now, we've talked about federal registration and the benefits that comes from it. And one of the benefits bleeds over into global protection because now we know that our songs can appear electronically over the internet or over other electronic distribution, means they can be heard across the globe. How do we protect our music across the globe? Part of this is down to the agreements that you have with other countries and territories, but that takes place only when you have the federal copyright registration. So again, if you're writing songs, you're recording albums, and you're not registering your materials with the Copyright Office, you're losing all the benefits we discussed earlier. but you're also losing out on the benefits to protect your music globally. But if you have registration, your works and are going to fall under the scope of certain agreements between the US and other countries, that will provide some level of protection. Beyond that, if your interest is in a particular country or particular geographic region outside of US, it's really important that you seek a qualified attorney to answer the questions about how best to protect your work, because it's beyond the scope of a video segment like this. A final note here is a situation where a band or solo artist is using someone else's materials, maybe in the form of sampling or maybe doing complete covers. You've been watching this maybe thousands of times. Somebody's taking some work, like making some cover of a song or whatever, or just using some samples for his project, for his song. Actually, I've been reading somewhere in internet that if it's like under 5 seconds, you can use it. Like if you use some samples or some sound, that's absolutely bullshit. Like you can't use anything which is like already released, like from songs or released songs that you hear on the radio, on TV, or wherever. So as I said, this is a sticky situation because normally the band is going to assume that it's fair use and that's okay, and they won't really look at all the elements of fair use agreement or to determine if actually it's okay in the eyes of the wall. And because the complications that are involved in reviewing whatever a cover is permitted or a sample is permitted, it goes beyond the scope of the segment. So my suggestion is to seek a qualified professional to help you determine whatever you're sampling or recording of cover is appropriate without license, and how much can you use of somebody else's material without asking permission. There is no number of notes. There is no number of bars or chords that will always provide you with that level of comfort that permissions will provide for you. So always assume that permissions is required wherever you use somebody else's materials.
Okay, guys, that's it. Everything for today. I hope you've learned something new. And at the end, I just wanted to remind you that our 1K giveaway is still running and you still have chance to join and win. So if you want to join, it's so simple. Just subscribe to our channel, comment and like our 1K giveaway video, which you can find in our channel, or check at the description below where I will drop link to the 1K giveaway video. Good luck and see you soon. Bye for now.